Okay, Mr. Marshall, let's see, there's a quorum of the board here. There's also a quorum of the CRC joining us tonight. Amherst Media is with us. We have attendees loading in over in the attendee group. I do believe we are good to go.
Okay, thank you, Pam.
You're welcome.
Welcome to the Amherst Planning Board meeting of July 15th, 2026. My name is Doug Marshall, and as chair of the Amherst Planning Board, I'm calling this meeting to order at 6:33 p.m. This meeting is being recorded and is available live stream via Amherst Media. Minutes are being taken. During the Planning Board's public hearing for zoning bylaw Article 18, Clean Energy Infrastructure, the Community Resources Committee of the Town Council will be available to join the discussion. Pursuant to Chapter 20 of the Acts of 2021, extended by Chapter 2 of the Acts of 2023, and further extended by Chapter 2 of the Acts of 2025, this meeting will be conducted via remote means using the Zoom platform. The Zoom meeting link is available on the meeting agenda posted on the town website's calendar listing for this meeting. Or go to the Planning Board webpage and click on the most recent agenda where the Zoom link is listed at the top of the page. No in-person attendance of the public is permitted. However, every effort will be made to ensure the public can access the meeting in real time via technological means. In the event public access is disrupted, we will post an audio or video recording, transcript, or other comprehensive record of proceedings as soon as possible after the meeting on the town's website. Board members, I will take a roll call. When I call your name, unmute yourself, answer affirmatively, and return to mute. Bruce Coldham.
I am here.
Fred.
I am here.
Thank you. Roy Johnson.
Present.
Jesse Major.
Present.
Hi, Doug Marshall, I'm present. Angus McLeod is not with us yet, and Jara Smith is our last
Present.
member. Thank you, Jara. So we do have a quorum. During the meeting, if technical issues arise and the discussion needs to pause, it will be noted in the minutes. Please use the raise hand function to ask a question or make a comment, and I will call on you to speak. After speaking, remember to remute yourself. To the general public, when solicited, please indicate you wish to make a public comment by clicking the raise hand button. If you have joined the Zoom meeting using a telephone, please indicate you wish to make a comment by pressing *9 on your phone. When called on, please identify yourself by stating your full name and address, and put yourself back into mute when finished speaking. Residents can express their views for up to 3 minutes, or at the discretion of the Planning Board chair. If a speaker does not comply with these guidelines,
Doug, we lost you. Oh, there you are.
For public comment. This public comment invitation is for members of the public to discuss subjects that are not later on tonight's agenda. So I see that we have 6 members of the public, and I will read their names as I usually do. While I'm doing that, if anyone wants to make a public comment at this time, please raise your hand and we will bring you in to speak. We have Felicity Hardy, Linda Slakey, Maura Keene, Renata Shepard, Richard Groves, and Stephanie Ciccarello from the town. All right, one last call for public comments. I don't see any hands raised at this point. Okay, we'll go right into the second item in our agenda. The time now is 6:38. This was advertised for 6:35, so we can proceed. This is a resumption of a planning board public hearing on a proposed zoning amendment, Article 18, Clean Energy. Board hearing is continued from May 20th, June 3rd, June 17th, and July 1st of this year. To consider amending the zoning bylaw by adopting Article 18, Clean Energy Infrastructure and associated amendments to Zoning Table 3, Dimensional Regulations, 5.11, Renewable Energy Accessory Solar Photovoltaic Installations / Battery Energy Storage Systems Uses, 6.2, Fences, and Article 12, Definitions. All right, so we do not have, we have the members of CRC with us tonight for this conversation. However, it's my understanding that this was not advertised as a hearing for CRC. So we, Pam Rooney, is it correct that we are not, you are not convening your meeting?
I'd like to convene it since we're here and we're attending. We are participating in this joint meeting.
Okay.
I don't know if it's absolutely required or not, but let's do it anyway. Mandy Johanneke.
I'm present. I would say it's required if any CRC member wants to talk substantively about this because we're a quorum. But I'm present.
Andy Churchill.
Here.
And Pam Rooney is here. We do make a quorum. I don't see Jennifer Taub was not able to be here tonight, and I do not see our fifth member, Alicia Walker, who may come in later. Thank you.
All right. In that case, Pam, would you like to start us off?
I would be delighted. I first want to recognize Attorney Murray, who represents KP Law and who supplied us with some really good information regarding the structure and content of Article 18, which we have in some shape or form been working on for 5 years. This is, and thank you. And we probably should have contacted you back, on version 8 or 9, but we really wanted to get it in good shape before it went to you for consideration. That said, I would like to open the floor for Attorney Murray to basically walk us through her general comments. I will ask if there were any questions that were generated by planning board members that were submitted to KP Law. There were 2 sets of questions from the CRC members. I just want to make sure that we cover everyone's points.
So, Pam, I don't believe there were any questions submitted from planning board. And just for your information, we didn't see the questions that you posed to Attorney Murray.
Okay. I had thought maybe they might be shared, and I apologize. Andy Churchill also sent in questions. Thank you. So, Attorney Murray, would you like to walk us through your considerations? And I don't know if it's okay. Now I'm getting reverb.
Yeah, the echo is back.
If Attorney Murray wants to address questions that were raised in the process of her explanation, she may want to incorporate it in that manner, but that's up to you. And then I'm going to go on mute so I don't reverb anymore.
Thank you, Madam Chair. For the record, as you said, Carolyn Murray from KP Law, and we serve as your town council. And I very much appreciate that this is a bylaw that has been in the works for several years, because I know certainly with some of my other colleagues at the firm, I know you've been discussing some of these issues. And I am happy to go through the comments as well as some of the questions. I know just before the start of the hour, I was saying informally before the meeting was convened, I didn't receive the questions until very late this afternoon and was skimming through them just prior to the meeting to sort of gather some thoughts. So my apologies if I haven't got a complete answer for every single one of them. But I want to just start with, I think this is a very good beginning of a bylaw. And I get the sense based on some questions that perhaps maybe I struck a nerve or maybe raised a few too many questions that maybe put you back on your heels feeling like, oh no, we have an awful lot more work to do than is necessary. And as I was looking at this, you have to remember, I haven't been in part of your conversations for the past 8 years, so I don't know what the intent was or whether the words on the page capture your full intent. But I think the best way I could perhaps summarize this is I now seem to understand that the intent here, it was twofold. One, to establish submittal application requirements for, I'm just going to refer to them as solar and BESS applications, should they come in under what I'm going to call conventional zoning, meaning your local zoning, and to also address the provisions from the 2024 Climate Act, which allows for this consolidated local permitting process. At times, and I also recognize that I think your bylaw was very much modeled after the state's model bylaw. And again, I recognize that a lot of work goes into that model bylaw, but it doesn't always clearly delineate when are we talking about what's required if an applicant chooses to pursue just the local permitting process versus if an applicant chooses this consolidated local permitting process. And this has been something that is still kind of evolving at the state level. But I think, to sum it up, I think the bylaw would work. And the way I'm sort of envisioning this is, certainly we have the applicability and we have the definition section. Then I think we need to take all of the submittal requirements that you would require for solar, all of the submittal requirements that you would have for battery energy storage systems. Maybe we also have to address when those particular uses might only be subject to special permit site plan review versus the administrative approval process. And then I think separately, perhaps it would be easier to have a separate section called the consolidated local permit process. And I'm going to take a step back for a moment, and forgive me if this is ground you've already covered with each other previously. But with the 2024 Climate Act, an applicant for certain small clean energy infrastructure facilities, and you've got them defined with it consistent with your proposed amendments to the use table, that below a certain threshold for solar, wind, battery energy storage, even anaerobic digestion facilities, if you ever chose to include those, they have the option of applying directly to the town as they would as if this consolidated local permitting process had never been adopted by the state. So if it required a special permit from the planning board, if it required a variance from the zoning board, they could still go ahead and pursue those separate procedures at the local level. The 2024 Climate Act then adds this option, and it is at the applicant's option, not our option, that they could instead submit what's called a consolidated local permit. And the consolidated local permit requires that an applicant submit everything that they would otherwise be required to submit under your local bylaw, plus. So there are some things. So for example, one of the things that jumps out at me in this draft is at times we make references to 225 CMR, the regulations for consolidated local permitting. But those are only going to apply to those who seek a consolidated local permit. We have references to the minimization and mitigation guidelines or site suitability scores. Again, those things only pertain to a consolidated local permit. So I think we just want to reorganize this a bit to make it clear that we have one permitting process if an applicant still chooses to come before the local boards under our standard, conventional process. Then the consolidated local permitting section can basically say you have to submit everything that's otherwise required as if you were going through the independent local boards for your various approvals. Plus, you shall also comply with 225 CMR 29. We don't have to repeat all of the provisions of that regulation here, but I think we do want to make it clear that we're delineating between the two. The other thought that came to mind was these uses are going to be allowed either by special permit or site plan review. And you do have very extensive special permit and site plan review provisions of your bylaw now. The only question I would ask is sometimes solar and battery energy storage systems, sometimes they have some unique characteristics that maybe not everything that is otherwise laid out in your existing special permit or site plan review provisions would address, say, some special concerns that you might have. So those are kind of what I'd say are the big threshold questions or thoughts in the back of your minds. And I don't know, Madam Chair, I know you've got other things that are on the agenda this evening. I don't know if it's helpful to go through sort of section by section or to go through the questions. I certainly don't want to monopolize your entire meeting this evening. So what would you prefer in terms of addressing answer sections or the questions?
I'm looking at Doug since this was a planning board meeting, at least the planning board meeting time frame. Doug, do you have comments?
Well, my comment is that I was expecting this to be a fairly in-depth discussion of this topic. And, when we've met with CRC in previous meetings this year, we've devoted a substantial portion of the evening to this discussion. If we don't need to do that, I have no desire to extend the discussion unnecessarily. From my perspective, CRC has been taking the lead on this initiative, at least since the solar bylaw work years ago, that was. So CRC, if you need us in the room to continue, we're here to meet with you this evening.
I would certainly appreciate making our way through as much as we possibly can while we have Attorney Murray with us. I see Bruce and then Stephanie have hands up.
Am I recognized?
Yes.
Yep.
Okay. I don't know whether I was the only one among you who was kind of perplexed when I read this, because this was not at all what I was expecting to receive. Carolyn, I'm an architect, or at least I used to be before I retired. And this has all of the hallmarks of changing the brief after the building has been designed. And so it certainly seems like one's reconstructing or reconsidering the basis of this bylaw. And so my question, I guess, is I'm trying to think of which of the many possible questions, but I think the one that is most close to the top of my pile is, you said this was a good beginning, and you indicated that let me preface this also by saying we've recently, we being the planning board, has recently spent a lot of time dealing with the ADU bylaw in town, which was another adjustment to our bylaw or addition to our bylaw based on the state um, act. And it was clear as we were beginning this, it would have been better if we had waited, because while we were deliberating, the state was changing the goalposts, moving things around, becoming clearer, and all of this sort of thing. The other intention that we have, maybe the primary intention for most of us on this, was to encourage clean energy, particularly solar, because I don't think, not being a farming community, I don't think there's much call for digesters in town. Maybe there's one farm that could possibly even be thought of as being interested. And of course, because of where we are, we're not a wind site either. There's no real wind sites in town. So I don't think wind and anaerobic digestion are here. But it seems to me that therefore that if we were to start trying to chase the way what you're suggesting, a reconstruction of all of this, while the understanding of this bylaw is emerging, that we'll be in the same boat again with shifting sands while we're trying to basically turn the good into the perfect. So essentially the question at the top of my pile is, are we here about to spend a lot of time trying to make the good perfect in a way that the enemy of good is the perfect? Or could we conscionably proceed with this bylaw, knowing that if we can spend this time, because we don't even know whether we've got anybody who's interested in supplying this. Let's find out whether we've got interest here yet. We want so long as this bylaw that we've got, the bird in our hand at the moment, is not discouraging clean energy development, number one, and not fundamentally flawed from a legal or a procedural prospect. My question is, why wouldn't we continue with what we've got and make the the improvements once we find out more about what's happening on the ground?
Thank you. Stephanie had her hand up for a moment. Do you want to speak, Stephanie?
I can wait, actually. I saw that Councilor Hanneke has her hand up, so I
Yeah.
defer to her.
Thank you. Mandy Jo Hanneke.
So I guess it's part question and part observation. The observation is, well, I guess the question is to Carolyn is, if you looked at this and ignored the 229 CMR or 239 or whichever CMR it is for the consolidated permit, if you ignored those references and our attempt to sort of address that change in the law that we attempted to do while the regulations were out, after they've been finalized and all of that, and looked at this as sort of just a solar siting and best siting bylaw, ignoring those sections that we brought in for consolidated permitting. What are your thoughts on that? And then you addressed this earlier. It sounds like if that seems good and doable and workable, what we need to be doing here, from my understanding of what you started with, is adding or moving some things that talked about 225 CMR and all of that to it's a sort of standalone section within this bylaw, or a completely different section within the zoning bylaw, and pulling it out of, say, a solar siting bylaw, and then maybe adding some stuff to that. And so I guess that's sort of, is that doable and workable? If we say, is the solar siting part of this bylaw pretty good, and any comments on the solar siting part of the bylaw? And then if we look at the Medway you provided and what we've gotten in here for some of the consolidated permitting, the local representative, the site suitability comments, move that into a different section. Is that a workable bylaw? And does the rest of the solar siting, can it all apply to either permit pathway?
Attorney Murray.
So maybe I'll start with the last question first, because I think this does go a little bit to Bruce's comments. When I suggested this was a good beginning, I didn't mean to say we've got a long road ahead of us. I actually do think your solar provisions and your battery energy storage system provisions are good as is. I think what is confusing is where we start to conflate when we're talking about the consolidated local permitting, and then we go back to provisions where it could apply to any solar or BESS application. So I think answering the question, could we take out all of the provisions or all of the references to the consolidated local permit and have a good workable BESS and solar bylaw? Yes, I think you absolutely could. Absolutely. And circling back a little bit to Bruce's comment about, analogizing this to the ADU experience, that, Amherst was not alone. A lot of communities, if you were ahead of the regulations, then you adopted bylaws, and then you had to go back and backtrack when the final regulations came out. And it very much feels like we are in that exact same system once again, with the state saying, as of October 1st of this year, we must start accepting consolidated local permits. But it's without regard whatsoever for our own schedules of town meetings. And the folks at DOER, they're very much aware of this. And they have taken the position that towns do not need to amend their bylaws or their ordinances in order to accept the consolidated local permitting. And I do have to say, I agree with that insofar as the way they have rolled out the guidelines, the regulations. My God, they have more guidelines for every different category. The application is 20 pages long, and then there's a 2-page checklist. When I step back from this, and I think if I could use another analogy, there's an entirely separate statutory scheme governing affordable housing projects under Chapter 40B. Yet cities and towns did not rush to adopt 40B bylaws. We just simply recognized that when a 40B application would come in, our traditional rules and procedures and timelines would set aside, and we'd all operate under the state statute and the state regulations. You could do the exact same thing here by culling this down to a solar and a BESS bylaw. Take out all the references to consolidated local permitting or site suitability and minimization and mitigation. Take all of that out. And if an applicant comes along and says, I want to file for a solar project that is going to be subject to, and I want to invoke the consolidated local permitting process, they can just go ahead and do it. Now, the flip side of that is that often is difficult for folks at the local level, who you find out perhaps maybe they're not really aware of what the consolidated local permit process is. Maybe they're not aware of the different timeframes that are associated with it. So is there some advantage to having some provision or a subsection in your bylaws that at least makes people aware of the consolidated local permit? Sure. And I know I shared the Medway sample with you, and I did that for 2 reasons. One was, to my knowledge at this point, Medway is the only community that rushed to adopt a consolidated local permitting bylaw. I had a lot of conversations in February, March, and April with a lot of communities who were thinking about adopting a bylaw. And most of them, to Bruce's point, said, we're going to take a step back and we're going to see how this really rolls out at the state level and see if we really need to do this, because we don't want to rush to adopt a bylaw only to then come back 6 months later and amend that bylaw to be consistent with whatever it was the state ultimately came up with. So I think I've answered your questions there, so I will pause if there are more hands up.
I put my own hand up. Thank you very much. I put my own hand up because I actually went through our bylaw, section by section titles, and I compared it with the material in Medway's actual solar and best siting bylaws. And then I looked at also what they covered in their consolidated example that was sent to us, and that was 3.6. And of all the items in our bylaw, each of our headings, each of our sections is the same as Medway's basic bylaw or their consolidated permit information. The only categories that I couldn't find in their documents were a couple of ours. One was hazardous materials and herbicides and pesticides, building permit and building inspection category, and waivers. And so that's 3 out of 22 of our sections that didn't seem to have a correlation with Medway. So I'm feeling a lot better thinking that we actually have the material we need if we wanted to pursue reorganization of it, rather than a reworking or a complete separation of the two items. It to me, it just makes more sense to reorganize, but I'll let other people speak. Andy.
Yeah, I was just going to say that I think that in some of our previous editing sessions, we had talked about the possibility of reorganizing the material in there so that there's one section that's the basic requirements, no matter what you are, and then there's a section that's if you want to do the consolidated process, here's what you want to do, or something to that effect. So I guess I'm just sort of reiterating what I think I was hearing from both Attorney Murray and from you, Pam, and I believe Mandy Jo. So
Thank you. Yeah. Mandy.
Thank you. Two questions that came out of that. One, I had this question last week and I didn't add it to my questions for you, for the attorney, but CRC's not in its hearing right now. Our hearing was continued till next week, but both bodies are in their hearings for this particular bylaw proposal. And would we need to restart the hearing process if we decided to separate out this proposed Article 18 into, say, a proposed Article 18 and a proposed Article 19? One that is solar siting and best siting, and one that is consolidated local permit process. Would we need to redo the hearing process, or is the current hearing process sufficient for that? Because that may make a difference on whether we try to keep them in the same article or not. And then if we were looking at, I think one of our priorities as at least CRC, we initially started this with a solar siting and best siting bylaw, not anything with consolidated. And then they passed the law, and then the regs came out and all of that. And we were like, we should deal with that. We're in the middle of this. Yep. But if we were to go back, in some sense, go back to, let's just make it solar siting and all, what would be the absolute minimum of consolidated permitting references or stuff or sections somewhere in our zoning bylaw you would say we need to add? Is the absolute, and I'm just going to give you an example. at least when I last read the regs, which were not finalized, I have not read the hundreds of pages since they finalized them. They were defaulting to, I think, the town clerk as the local government representative if the towns did not define their own. It's not necessarily who we want to be our local government representative. Is that something you would say while you're in this hearing process, while you're here, absolutely take the chance to define local government representatives somewhere in your bylaw, wherever it is? And if that's the case, what other things would you say, do it now while you're here, while you've got this process going versus, wait and see?
So to your first question of, do we have to restart the process? No, you do not. If you told me tonight that, oh, we want to do a standalone solar and BESS and a standalone consolidated local permitting, or maybe it's an Article 18A and 18B, whatever. No, you have already put everyone on notice that this is exactly what you're talking about. How to regulate solar, how to regulate battery energy storage systems, and also how to address the consolidated local permitting process under the state's new requirements. So all of that is here. And if you suddenly break that into 2 articles or an A and a B, I don't think that makes any difference, because anyone who had any concerns has been put on notice by virtue of your public hearing notice. If you were to tell me, however, I hear that, Amherst isn't really a town that feels the need to add wind and anaerobic digestion facilities to the bylaw. But if you were to end tonight and say, just in case, you never know, we get a lot of wind in the Pioneer Valley and off the Berkshires. Maybe somebody will want to put a wind turbine out here, right? If you were suddenly to say we want to add wind and other types of clean energy facilities, I would say those would have to be advertised, because no one had any particular knowledge of that. As for the bare minimum of what you need, so you're absolutely right. Your memory is correct that the draft regulations identified the town clerk as the local government representative. And I suspect that the Town Clerks Association had an absolute uprising and made it perfectly clear to the state that, oh, no, you don't. You're not putting this on us. And so the final regs identified the chief administrative officer or designee, whoever that may be. So I see in this draft, you've designated the town manager or designee. At a bare minimum, I would suggest that we identify the consolidated local permitting process could literally almost be like a single paragraph that just says, in addition to seeking a special permit or site plan review as enumerated in Article 18, applicants have the choice under the 2024 Climate Act of submitting a consolidated local permit. If an applicant chooses this process, they shall comply with, and we plug in the regulations or the guidelines. And I think the only thing we really need to worry about would be identifying who the local government representative is. Because while I appreciate that we've plugged in the town manager, I doubt the town manager is going to want to really issue these permits as well. I think it is going to be ultimately the town manager's designee, whoever that may ultimately be. And if we have a sense now that, a lot of communities that are doing this sort of like informally, they are having the select board take a vote to say, make the planning director or comparable title be the person who actually coordinates the consolidated permitting process and issues that consolidated permit.
Carol, just for your information, we actually did ask staff who the most appropriate person would be, and they said town manager or designee, which is how we came to that conclusion. That's encouraging. Bruce.
Just let's first of all make sure that none of you has follow-up questions related to what Attorney Murray just said. Or Hearing not. Um,
Well-
Carolyn, I was interested in the analogy to the 40B, and that we basically allow or expect that our zoning works until it doesn't, and then 40B is allowed to take over. But the question is, or the observation is, that 40B has a kind of an insurance capability, if you like to call it that, which is if you have over 10% of affordable housing in the SSI, then you get to choose, and you can say no to a 40B, which we would call them a hostile 40B, and we could choose. But not frequently, but yeah, actually, on the greater scheme of things, we frequently do engage and embrace friendly 40Bs, and we look at this 40B. So I really understand, at least I have an understanding of what you're saying, that we could embrace the state part of that as need arose, shall we say. But the question then is, in the absence of being able to choose, which we can with 40B because we happen to have and have for as long as I've been here, which is 40 years, above the 10% threshold. So we have negotiating power, we have choice. But that doesn't apply, I don't think, in your analogy, as far as the clean energy bylaw is concerned. So the question is, would we have any concern, or should we have any concern about the absence of a kind of a filter, if you want to call it that, such as the 10% analogous to the 40B, the absence of that in relation to the clean energy bylaw, is that in any way would cause any invidious circumstance so far as our town was concerned, in which case then we would be moved perhaps to be more proactive. But if not, your analogy sounds very helpful and very reassuring.
Carolyn?
Oh, I'm sorry. The short answer to the question is that unfortunately, unlike 40B, where you were alluding to, there are safe harbors where we can say no. There is no similar mechanism here. It is so if we have a certain number of solar installations or a large battery energy storage system, that we are somehow saved from the next application that comes along. That unfortunately does not exist. One thing, however, to also bear in mind is that solar and related infrastructure for the storage of energy, as a result of recent case law over the last 5 years or so coming out of the Massachusetts Appellate and Supreme Judicial Court, they're treating solar as many are calling them Dover protected uses. And I don't, Dover to a true purist means no, we're talking about religious and nonprofit educational institutions. But Chapter 48, Section 3, which is the so-called Dover Amendment, has expanded over the years to include other uses. And we're now at a point where solar cannot be prohibited, and it cannot be unreasonably regulated so as to ultimately prohibit it. And with solar, some courts are starting to also sort of tag along battery energy storage systems in that same vein of having some protection from zoning. I will say that, as a footnote, the model solar bylaw that the state issues makes reference to a town of Duxbury case. That was actually our case, where a land court judge did say that battery energy storage systems are entitled to the same protection as solar arrays. That was appealed to the appeals court because the town absolutely put their foot down and said no. And unfortunately, before it ever got heard by the appeals court, the applicant withdrew. So we haven't quite got a higher court level yet telling us how to deal with battery energy. But you see from like the Tracer Lane decisions and a Walpole Kearsarge decision that if you don't allow solar in a fairly in a somewhat there is no hard and fast number or percentage, but we know from Tracer Lane in the Kearsarge case that only allowing solar installations on what amounts to 2% or less of a town's land area is deemed to be basically a prohibitive bylaw. That there's no place in town that these things can go, therefore you're effectively not reasonably regulating them. So I'd say that's sort of the corollary in a way to 40B and safe harbor, is that we could face a legal challenge at some point if we don't put something out there that shows we are trying to reasonably regulate solar and battery energy storage systems.
Thank you.
Thank you. Actually, on Bruce's correlation with 40B, I think perhaps what we're dealing with here is more the process where, in fact, there is the same kind of 12-month timeline, and all of the boards and committees who weigh in on a project must do so in a consolidated fashion in order to process things in a fairly timely manner. I was actually going to go back to Mandy's question about bare submittals. In looking at the Medway bylaw itself, which is their 8.1 or 8.1, 8.11, and then basically all of the same requirements that we have in our bylaw, our draft bylaw, are there. We may be more specific about a distance to a water supply. They probably get their water from the Quabbin. They don't have to worry about this. But so those are the kinds of additions that we have in our draft that seem very reasonable. In looking at our own zoning board rules and regs, they talk about evaluating impacts from traffic, et cetera, et cetera. It's all essentially there. It's just that as we pulled all this material together, it felt like, because it's such a complex thing, and if a permitting board was being required to handle this in a timely manner within that 12-month period, it made more sense to have everything at your fingertips. All of the submittals required, all of the plans, all of the reporting requirements laid out in one place so that nobody had to go fishing through, the ZBA rules and regs, which are, by the way, hard to find, to pull the pieces together. And I think that's where I think that's the tack that we took. At some point after Doug asks his question, I wouldn't mind showing this, just the comparison that I did with Medway, in terms of, just so people have a sense of it, if people are okay with that. Doug.
Yeah, just two quick things. One, I just want to recognize that Angus McLeod arrived at 7:13. So for the record, he is now with us. And I guess I'm finding the comments from Attorney Murray to be pretty clear, that we need to just go back and move some pieces around and reorganize a little bit. And then we can proceed pretty much with what we have. So I'm feeling like we have a pretty clear path to get to a final product. I'll stop there.
Do people mind if I share this document that's highlighted? I just want to see yeses or, I mean, no's. It'll be quick. Let me just show it right here and see if I can pull it up.
Quick, because I think Doug is right.
Can you see what I have here? And is it large enough to read?
Yes.
For me, yes and yes.
Okay, it's essentially Medway their basic solar and best bylaws are in green. So and so our material is comparable to theirs for section 1801, purpose, 1802 applicability, 1803 definitions, 1804 compliance with laws and ordinances, section 1808 submittal requirements, 1809 dimensional standards, 1810 design requirements, 1811 additional design requirements for specific types of installations, stormwater management and erosion and sedimentation control, facility maintenance and modifications, those are two more sections, reporting and monitoring they cover, and financial surety and decommissioning fund, and lastly, abandonment or decommissioning. So those are all things that they have in their basic bylaws that we have here. The items in blue are what are found in their consolidated permit, and that includes our 1805 pre-filing requirements, which only applies to consolidated permits. 1806 site suitability assessments, which also only applies to consolidated. Fees, maybe they have fees elsewhere, I didn't see it. An emergency response plan, which they cover in the consolidated document, but not in their bylaw. And finally, transfer of ownership. So those are things they covered in their 3.6 consolidation, I'll call it consolidation bylaw. So that, and again, the only ones that they didn't include either anywhere were the hazardous materials, building permits, building inspections, and waivers, which may have been there in as a subheading under something else. So I will stop sharing. But that, I just wanted to illustrate that it didn't seem as onerous as.
And did they have anything that we didn't have?
Not that I noticed, but maybe I wasn't looking at it from that perspective. So if we were to talk about next steps, I'm summing up what I think I've heard, and that is that if we determine that we keep it as one document, we could work to be clearer in our introduction of the consolidated permit process, and essentially list, the following sections are going to be covered for those applying for a consolidated permit. The remainder of this document applies to everything, including consolidated permits. And that's in a nutshell. We're done. We're done. Here we got an answer. Andy, he's going to throw cold water on that.
No cold water, but I'm just trying to remember. We had talked about reorganizing anyway, because there were some sections that applied to everybody and some that didn't apply to everybody. And so was that sort of if you're a smaller operation, here's what you need to do. If you're a bigger operation, you also need to do these things. And then if you want to do consolidated, then here's the process for that. Is that sort of what we were thinking? Because we were already talking about trying to make it, it's 18 pages long. And if you're just a small operator trying to do something fairly small, it would be nice to make it clear, that they don't have to do everything. So is that what we're talking about doing anyway?
Yeah, Mandy.
Yeah. I think after this conversation, I think we need to reorganize it. As Andy was just saying, what we were talking about, I think it's time that we need to see that reorganization so that we can really discuss. We still have blanks in what I think one of them, what will apply or won't apply to one set of tiers. So we have to make those decisions before we can vote on this. So I think it's time to reorganize. If we don't have to hold a separate hearing process, I think I would probably prefer if we split out all of the consolidated permitting into a separate article, Whether it be a separate article or some section of the bylaw that it makes sense to put it in. And I couldn't tell you now whether there is. I know we have site plan review articles and we have special permit articles, so maybe we just need a consolidated permitting article too. Um, um, because I think that makes it easier for the reorganization, because then you're talking about two different things. You're not combining two different things into the same article. I think I was really only for keeping the two together because we really are talking about citing and what application process you're using. Only I was originally leaning towards that if we had to hold a whole new hearing process. But since we don't, I think it's cleaner and clearer if we split the two out. And we've got, you know, solar infrastructure and BESS infrastructure. Solar and BESS infrastructure is one article, and consolidated permitting process for clean energy and small clean energy in whatever it's called, energy facilities in a different one. I think it'll make it easier to review too.
Doug.
Yeah, I guess, Mandy, I'm gonna argue in the opposite direction. That we have a section called process somewhere at the beginning of Article 18, and that it delineate that there are two paths, and the first path, is pretty straightforward. It's subject to all the requirements elsewhere, and that wants to go through a consolidated permit, they should follow these special things. And the reason I don't think I would argue, the reason I would not separate them is that this consolidated permit process is only applicable to solar and BESS projects. So it belongs in that area. If that was a new process that could happen for any kind of project in town, I'd say, yeah, do it as a separate article. But that's my 2 cents, basically off the top of my head. And whoever revises this can take that into account. Thank you.
Well, Doug, just as a quick follow-up to that, so if there was in fact some kind of consolidated process section somewhere, would that not also apply to 40Bs, 40Rs, 40 whatevers that come down the pike? I'm looking at Attorney Murray. I don't know, is that?
I personally haven't had enough experience with those and studied those processes enough to know if it's identical.
Mandy.
I wanted to ask Attorney Murray a question with something Doug just said, because I don't think it was accurate. We are only addressing, and we've only talked about solar and BESS, but because as Bruce said, we don't necessarily expect a wind project to come in or an anaerobic digester project to come in, but our zoning bylaw, the way it's written, does not prohibit those projects from coming in, just like they didn't prohibit solar, even though we didn't have a use category for solar. We are not an exclusive use category only zoning bylaw. We are find the closest use category if there's not a specific one bylaw. So I think that means that the consolidated permitting process under 225 CMR 28, I think that's what this one is. If there was an applicant for an anaerobic digester facility, could choose the consolidated permitting process, even though we don't have a use category for that in our town, and they would have to follow it. And so the consolidated permitting process that we identify, however we identify it, whether within this article or as a separate article, would apply to that process, right? Or could we, I mean, I would think we would want it to if we wrote it, that we wouldn't want to write a process that only applies to consolidated permits for BESS and SPI, even though an anaerobic digester applicant could apply, because we don't have no exclusive we don't have an exclusive bylaw, we have sort of an inclusive bylaw. Is that correct, Attorney Murray?
You make a good argument, and I think it could be done either way, whether you did this all as Article 18, that, let's also remember your current title, should you choose to stay with it, is Clean Energy Infrastructure. So even though we're really only talking about solar and BESS, if an applicant for, a wind farm were to come in, it would likely also look to Article 18 for, some guidance as to what would be required. So could we do Article 18, Clean Energy Infrastructure, all of the submittal application requirements? If you choose to go the local permitting process, have a separate paragraph subsection that refers to the consolidated local permitting process that says you have to submit everything up above. The only difference being you now also follow the provisions of 225 CMR 29. And oh, by the way, the local government representative is the town manager or designee. You could do that. You could separate them out into two entirely different bylaws, 18 and 19 or whatever numbers you assign to them. One thing to bear in mind is the way the statute was written in the regulations. They only identify solar, battery energy storage, wind, anaerobic digestion facilities at the moment, but they also say they open the door for other clean energy, infrastructure facilities that have yet to be identified. So there could be a possibility in the future for something else that we don't even have the vocabulary for yet that could come along. Again, could you then address that under your clean energy infrastructure bylaw? I think you could. So I guess that's my way of saying whatever your preference happens to be. I do have a little bit of sympathy for, I spend an awful lot of time doing like zoning rewrite projects for a lot of our towns. And when you do have something like a separate consolidated local permit bylaw, that's, let's just say it's number 25 is the number it's ultimately assigned to. Sometimes it really does feel like a complete disconnect, not just in terms of the numbering in the bylaw, but also substantively, where someone flipping through pages says, well, what the heck is this all about? So, whatever your preference may be, I just think that for the consolidated local permitting section, whether it's standalone or a subset of Article 18, I just think we want to be clear that it relates to these types of small clean energy infrastructure facilities, however you choose to structure it.
Any other thoughts on this dilemma? I think I'll weigh in then if nobody else is speaking. I am intrigued by the idea of being able to direct an applicant to the consolidated process in the text of this article. For the reasons just stated, it doesn't, even if it's sequential, the regs may change in the state. We're still referring people to those regulations. I think that seems to make more sense than perhaps in looking at the Medway example, which is very great, but that's 4 or 5, 6 pages of material that in many cases is it's just kind of, well, I'll just say it's just sort of process. There's an application review. Well, we already cover application review process for ZBA and for the planning board. We probably don't really need to repeat that. How do you deal with modifications or it just seems like there's a lot of material in there that I wouldn't necessarily, I mean, ours is pretty overbearing to begin with. Why would you put somebody through that again? So it seems to me that we could certainly we could certainly glean from that example and craft a paragraph, a couple sections. The blue sections that I highlighted are the ones that pertain, to the consolidated process. Maybe I'd be certainly happy to tackle that. Andy.
Yeah, I mean, other folks in this group have been working on this a lot longer than I have. So coming in fresh and talking to it about people, the question that comes up is it's a pretty long bylaw, and people will ask, are we trying to encourage solar energy or discourage it? And I think we want to encourage it, encourage good projects, and so the more we can do to make this as clear as possible and not just, you need to hire an army of lawyers. Sorry, Carolyn. So that, yeah, to even think about applying, I think that's better. So if we can add a paragraph that sort of, says, here's the process piece. You've got this process or this process. And if you do that process, it's all outlined in the state regs or whatever. And then if you're smaller, in a particular tier, you have these requirements. If you're in another tier, there's some additional ones. Just allowing people to move through the bylaw as easily as possible, I think would be helpful.
Bruce.
Doug may be about to do the same thing that I think I might be trying to do. It seems to me, and correct me if I'm wrong, that you, Pam, Mandy Jo, that the CRC is prepared to do this reconstruction, rearrangement, take this initiative that you've described and that you seem to have a better handle on, certainly I do. And indeed, you have done this work, the CRC has done this work prior, and it's come to us for review. But I'm aware, I think, that this is the hearing of record, and that what seems to be required here, because Mandy Doe has made it clear that we can operate, or has clarified that we can operate as on the basis of a continuation. And so I'm thinking that, is it not time for us to move for a continuation? Is that what you were going to do, Doug, or you got something else? Because if you weren't, just let it be said that if you come back to my hand, I'll be moving for a continuation. And I'll stop there for the moment.
Doug.
Thank you. What I was going to say was, in a kind of as a follow-up to Andy's comments about the level of encouragement versus discouragement that the bylaw draft conveys. As you know, you did not, CRC, you did not attend our last meeting, but we did talk about how we might recommend the bylaw to council when we closed our hearing at our last meeting. And at that meeting, I think there was probably a majority of the board that felt that we were supportive and we could recommend it, but that we did not feel it was as encouraging as we hoped it would be, or as we would like it to be. And so I would ask CRC to keep that in mind if you are going to be going back over it again.
Jara.
Thank you. Yeah, I just want to echo what Doug said and what Andy shared. One of the things that we have brought up in previous planning board meetings is the importance of running this by an actual solar developer. So Carolyn, I'm wondering, like, if you ever work with solar developers who could take a look at, what our bylaws ends up looking like, because to their point, like, we'd like to encourage good projects, and we have one idea of what that might look like, but it might look different to somebody who's actually doing the project. So I'm curious, what are your thoughts of involving them at some point in this process?
I would certainly never say no to that because I'm certainly mindful of the fact that there's always something that, folks that are on, the industry side of this, that they look at it and say, oh, well, this is, it doesn't really work that way. Or, this needs to be a little bit, needs to be tweaked a little bit, or maybe this is really something that becomes a deal breaker for many of them. So I would never say no. The only caution I would have is remember who they're representing. And so as much as I always appreciate the view from the other side, this is the town of Amherst bylaw. It is designed to protect your unique characteristics as a beautiful community. And I know just from listening to you all tonight, you're not going to let somebody just run right over you. But, a little bit of healthy skepticism where in that regard is always a good thing. So like I said, I wouldn't discourage it, but just recognize that we don't have to accept every comment or criticism that they might provide.
Yes. Yeah. I couldn't agree more. Certainly folks will come with their own agendas. But I mean, I guess more from the user experience, just like understanding, being able to navigate the bylaw clearly, less so, we'd prefer the setback was a little bit less or something, but more just like easily interpretable. But thank you.
Wanted to come back around to how this might get restructured. Actually, I want to respond to Jara's last comment. The Medway bylaw has significantly larger setbacks than we show in our version. In terms of the applicability, I was appreciating Medway's approach to their their opening salvo, if you will. And they describe 4 or 5 categories of applicability, which we tried to get at with our tables, but they actually called them out. And so category 1 is roof-mounted facilities do not need to comply with other sections of this bylaw. Number 2 was small-scale ground-mounted accessory to residential require site plan review under section X. Third category was solar canopies accessory to residential. Those are allowed in certain districts and are subject to the requirements of this bylaw. Item 4 is all other small scale and large scale installations subject to the requirement of this bylaw. And are allowed in the zoning districts only as specified in the table that they reference. And then lastly, that it's just their planning and economic development board that's the special permit granting authority. So it seems that in applicability section itself, we might be clearer. It's also where we got really muddy with the following sections apply, the following sections don't apply. This might be a very clean way to call out the different levels of action. And perhaps in that, I'm looking at Attorney Murray, perhaps in this applicability portion, we can refer consolidated permits to, we send them in the right direction in this applicability portion. And I'm asking if that makes sense.
I think it does, especially if we're going to have, say, a separate subsection or a standalone bylaw, however the reorganization actually plays out. I think it does make sense to include whether it's category number 5 or 6, whatever you're up to there, to also include consolidated local permits pursuant to 225 CMR 29 or 28, whatever it is. I think that makes perfect sense.
And then we could still have several sections that are specific to the consolidated permit, like the ones that we identified, which were the pre-filing and the site suitability sections.
Yes.
That was a question. That was sort of a question.
Yes. Or you could, like I said, or you could decide we're not going to repeat all of that here. One of the things that I see a lot in bylaws is this: there is a tendency to, and Medway was one of them. There is a tendency to want to regurgitate an awful lot of what is in state law. And of course, the danger to that is the state changes something and we're constantly amending our bylaw to be consistent with it. So, like the site suitability scoring section that you've currently got in this draft, if we whittle down consolidated local permitting to just a paragraph that says an applicant may add it, on its own choosing, submit a consolidated local permit pursuant to 225 CMR, in which case all of the above submittal requirements shall apply. We don't need to worry about whether or not you're one of those projects that has to have a site suitability score, or whether you're exempt under the state. We don't have to worry about the process for challenging the site's suitability rating. We don't have to include provisions for, minimization and mitigation. It's all there on the state side of things. It might be that you want to make it somewhat user friendly, and maybe you do want to at least provide references to the titles to those other documents, so that folks realize there's this, every time I visit DOER's webpage on clean energy, it's gone from, about 3 or 4 bullet points to a page and a half now. It can be a little daunting, but we don't have to repeat all of it here.
Yeah. Any other comments? And I'm looking specifically at our CRC members. Since we have a meeting on the 23rd, we will be talking about this again. Mandy.
So, I think what I've been hearing is we need to do the reorganization. We need to clear up the applicability section. And we need to at least draft some sort of move everything that relates to the consolidated permitting process into one section instead of throughout the whole bylaw. And then we can debate whether it stays in this article or not. I'm happy to take an attempt at that for our next CRC meeting, because I think I've got an idea of what that might look like. But did I summarize where people are going and what people are accurately?
Yes. And I would be greatly appreciative of that effort. Can we vote on that? Bruce?
I don't think we need to vote on it. I think.
I was kidding. I was actually kidding.
Oh, good.
Sorry.
Doug, I would move that continuation for, and I know we have to put a date certain. So when it say a month from now, what are we? The the second meeting in August. Because it would seem to me, Pam, that you all wouldn't have moved the ball forward enough for us to be contemplating anything at our next meeting, at the first Wednesday in August. But we don't need to put it out too long because we can always just perfunctorily continue the continued meeting. Is that correct, Doug? I mean, it seems
Well,
like
I know that we are operating under this October deadline by which towns need to have the bylaw in place. So I would ask Pam, would you like us to put it on our agenda for the 5th of August in case you guys are ready for us with something for us to,
Yeah.
say we recommend version 14, so that it's sort of a static document at that moment. And if
I
that's
think
the
it would be
case-
I think it'd be very appropriate to have it on your agenda. Yes, thank
okay,
you.
so August
Oh,
5th. So
well, in that case, move to continue the hearing to August 5th at 6:35.
Mhm.
all right, Pam Field Sadler, do we have other items on our agenda already for August 5th?
We have some small things, but at this point, there's room for that right at 6:35 for
Okay,
clean energy. Thanks for
All right.
asking.
Doug, I
So-
noticed that Carolyn's got a hand up, and if it's a point of order
yeah.
comment, we should take it before we vote.
Carolyn.
Thank you.
Carolyn.
Thank you. I just wanted to clarify one thing. We don't actually have to have the bylaw in place by October 1st, but we do have to be prepared to accept a consolidated local permit application if a would-be applicant out there chose to submit one by that date.
Yes, I
understood it. I'm getting reverb again.
Go ahead,
Quickly,
Pam.
I'm going to try. If an applicant plans to submit a project, is it the act of submitting the project or having gone through the full site suitability analysis and pre-filing process that they go through before they submit the project? So in other words, do we have a lead time of 3 or 4 months while a project is getting fleshed out at the state level, meeting all the pre-filing requirements before it hits our front desk?
Yes, all of those pre-filing requirements are supposed to be done before they submit an application to you.
So we would know. Sorry,
Go ahead.
I'm not sure when I trigger.
I actually think something's going on with Carolyn's microphones. She's getting the reverb. It seems to be happening when she's unmuted.
So that makes me feel a little better that we will know in advance before someone comes knocking on the door requiring a consolidated permit. Is that true?
Yes, and apologies if the microphone is causing it. It doesn't appear on my end to reverberate. So, but yes, because one of the pre-filing requirements is like the community outreach meeting, and they would have to coordinate and contact members of the town to coordinate that meeting.
Nonetheless, we need to keep going on this. But maybe the
right.
coals aren't quite as hot as we walk across them.
Okay, so Pam, I'm going to go ahead and second Bruce's motion that the planning board continue its hearing on this topic to August 5th at 6:35 p.m. So planning board members, let's take a vote on that. I guess I'll ask first, is there any further comment from board members? All right. All right, I'll just, I guess I feel like I really ought to ask for any public comment before we do this. So I see we still have 6 members of the public present. Do any of you want to comment on the discussion tonight on this topic? Okay, I don't see any hands raised, so we'll go ahead, planning board with our vote. This is the vote to continue. Bruce,
Aye.
Fred,
Aye.
Roy,
Aye.
Angus,
Aye.
Jesse,
Aye.
Chera,
Aye.
and I'm an aye as well. That's unanimous. This hearing is now closed, or continued rather, closed for tonight. CRC, thank you for joining us. Attorney Murray, thank you for joining us. Are there any concluding comments before we bid you adieu? Mandy?
I was just gonna, I think we're done, so I was gonna move to adjourn CRC.
Yeah, thank you. I'll second it. Let's take a vote. Andy? I
You're
think
muted,
he's-
Andy.
I was just going to make a quick comment before I voted, but is that okay?
Yep. Go ahead. Go ahead.
I just wanted to say that I think it's a really good thing that CRC and the planning board are doing these things together in this way, rather than making staff and everybody else and citizens run through it separately. So I appreciate the collaboration, and I vote yes to remove ourselves from this collaboration right now.
Mandy?
I'm an aye to adjourn.
And Pam is an aye to adjourn. Thank you, Planning Board, for letting us join you, and staff for supporting us both. And Attorney Murray, thank you very much.
And CRC, thank you for accommodating our schedule.
We're gonna
Thank you,
leave.
everyone.
We're gonna leave. Bye. Bye.
Okay, time is 8 o'clock. We often take a break at this time. Why don't we take a 5-minute break and come back at 5 after 8? Please turn on your cameras when you return so we know you're back. Hey Pam, I wondered if you could take off the break slide and just let us see everyone again. Thank you. You are muted. I know what you said. Angus, can I assume from your presence that you do not yet have a new child?
Correct. And still we wait.
Okay. Well, I'm glad you could join us. Well, we'll see in the second half of this meeting whether we have any reverb or not.
I know.
I'm not sure who it was, but that was my best guess.
It was
Doug, I think you are right.
I mean, it was either, well, anyway, I don't know. I wasn't sure, but I had a pretty strong suspicion.
It was great that you could see a pattern because I couldn't see a pattern.
Well, I'm not 100% sure about it, but she was the only one who wasn't in our previous meetings when we didn't have reverb.
Well, I wondered if it had anything to do with the air, the energy in the air, and internet, like with
Initially, we had a Comcast truck out front of the house working on internet this afternoon, and I've had intermittent messages on my screen that my connection is unstable. So I don't know, maybe it was me. I don't know. We'll see whether there's more reverb in the rest of this meeting. But we're all back. The time now is 8:09. We can proceed with our agenda. So
I'm going to
Pam,
start bringing some people in.
Yeah, why don't you start bringing people over?
Okay.
All right, so this third item on the agenda is a public hearing. It's continued from July 1st of this year, SPR 2026-04, Amherst Community Land Trust. Project is at 174 Amity Street. Request site plan review approval under sections 3.3212 and 3.01 of the zoning bylaw to construct an affordable duplex complementary to a 3-unit townhouse on the same lot with parking and associated site improvements located in the RG General Residence Zoning District on map 14A, parcel 332. So this hearing is now underway. And I'd like to welcome Felicity Hardy and Linda Slakey again, representing the applicant. Bruce Coldham, I assume you are going to recuse yourself again from the board for this discussion?
Yes, I was just about to propose that. I will, insofar as the technical design documentary and so forth person for this project. I will do the same as I did last time. I will assert for the record that I have no financial interest in the project, and I'll ask if the board is prepared to, with my screen off, allow me to remain in the room to answer specific questions of matters of fact, and that alone.
All right, that's acceptable to me. Any other board members object to that? Okay, we'll proceed on that basis. So Felicity and Linda, welcome, and I believe we have some updated drawings. If one of you, or actually Linda, I'll start with you. Linda and Felicity both have their hands up, so
Yeah,
you guys can decide how to introduce the
it-
project again.
it's Felicity that will make the presentation. I just wanted to let you know that in line with the other communication problems you've had tonight, my camera is for some reason unstable. Every time I attempt to turn it on, it turns itself off. So that's why you're seeing my library footage picture there, but I'm very much paying attention.
Thank you very much. All right, Felicity.
Good evening, Mr. Chairman. Thank you again for this opportunity to present this project to the planning board. My recollection from our meeting on July 1 was that there were a couple of open issues. The board asked us to return with an updated site plan to address those issues, and that was filed with Ms. Powell, I think a day or two before. My copy of that plan is it has a revision date of 2026 07/13, so July 13 of 2026 revised. If it's possible to bring that up, I'll just walk the board through the changes that have been made.
Felicity, do you have those drawings yourself?
I have a PDF of the
Yeah.
drawing that I downloaded. Would it be easier
Right.
for me to share?
It would be easier for you to share rather than Pam. I just noticed last time that, Pam was taking notes about our discussion, and then we had to interrupt her now and then to get her to change a slide or move her cursor. So I think if you, Felicity, shared that it might be easier for Pam, and that way you could highlight anything you wanted to highlight with your cursor.
Sure, I'd be happy to.
Okay, I'm going to stop mine. Did you
Great.
see mine?
We do.
Yes.
Okay, so I'm going to stop mine.
And
Okay.
you should be able to share your screen, Felicity. Yes.
Okay, can you see that?
Yes.
Yes.
Okay. So the principal concern of the planning board last time was the location of the electrical transformer. You'll remember that this came up as kind of a last minute issue. That's why it wasn't on the plan that we had submitted previously, because in the course of organizing ourselves for getting a construction contract, we learned that Eversource requires the electrical conduit to be coming in underground, which requires a transformer pad. I'm going to try to manipulate this. I'm not that great with this kind of stuff, but you'll see, at least on my plan, that we are showing the transformer pad sort of midway between the two structures, screened with evergreens. This location is really dictated by the requirements for Eversource about where the transformer must be located. So Bruce took those requirements and kind of sussed them out, and Bucky Sparkle has put them on the plan in this location. That was the first set of concerns. Second set of concerns had to do with the accessibility of the accessible duplex to the trash enclosure. And you will see on this plan, we've made some changes so as to make the pathways more accessible to somebody who is mobility impaired. When we were in front of the board on the first, we talked about the fact that there was going to be a single trash enclosure here, which I'm circling with my cursor. And the board suggested that it would be appropriate to install, instead of a stepping stone walkway or something like that, to have something that would be easier for somebody who is in a wheelchair to or otherwise mobility impaired to access the trash enclosure. So you will see on this plan that we have converted some of the walkways to a bituminous walkway, and that walkway goes right up to the ramp on duplex. One thing that we also that our group also discussed in connection with the trash and the making it easy for somebody who had a disability to kind of get rid of their trash, seemed to us that, maybe having them come all the way over to here to access the trash enclosure was somewhat onerous. So we've also added a new smaller trash enclosure up here at the edge of the parking for the duplex for additional trash. So that's just sort of an additional feature that we've put on the plan to make it maybe a little bit easier for the people in the duplex to dispose of their trash. We've added screening in the corners of the parking for the duplex. So I'm kind of showing that here. And in both the parking area for the duplex and the parking area for the townhouses, we've added bollards for possible future electric vehicle charges. So you can see that identified here, and also down here. There was a comment from Ms. Rooney at the end of the hearing last on the first, which frankly, I have to confess, went over my head a little bit. And I think it had to do with the development of swales. She said something about scouring. And honestly, I didn't understand the comment, but I believe whatever that comment was, it's been addressed in this plan, and I'm going to leave it to Bruce to answer those questions if they arise.
Felicity, I see that Bruce raised his hand. He may want to elaborate.
Yes, the toe or the core or the low point of the swale, as it was shown originally in Bucky's drawings, coincided with the edge of the paving. And Pam thought that that would cause scouring. So what we've done is just pull essentially the bottom of the swale, the drain channel of the swale has been pulled back a foot from the road. So the scouring has been taken care of. I mean, there won't be scouring. It's lawn there, and it'll stay grass, we think.
Mm-hmm.
And the extra trash enclosure is really an option. The habitat fraction of the clientele would prefer to have a separate trash enclosure. The question is what is the economics of having the trash haulers make 2 stops instead of 1? And what's the financial difference, The other has to do with how frequently the pickups are. We don't yet know whether it's weekly or bi-weekly. I mean, every 2 weeks. So, however the trash contracts materialize or sugar out in terms of economics and the available frequency, we have in the arrangement that we show now, we can accommodate any contingency. And the note about the screening enclosure is really the screening was already shown there. The question last time was, are these existing trees or is it new planting? And we've just clarified that it's always been intended to be new planting. And we show that the existing pathway, that's the pathway that runs around the eastern side of the existing townhouse, that was originally shown to be just to maintain the existing. But as with these trenching and so forth, it became apparent that we were, and the water and so forth, and that is the other, it became apparent that we're going to be digging up a lot. So it was decided that it would be prudent to redo that pathway, at least up to the porch of the first portion of the townhouse, if not for the last leg. But again, we'd like to give ourselves the option, depending on how excavation and disruption happens, to be able to renew all of the existing pathways there, as well as build the proposed new ones. And that's what is currently shown. And then we have shown the water line, which we pretty fully described last time, but now it's on the drawing.
All right. Let's see, I guess, Felicity, I assume that's the extent of your narrative. And
Yes, unless you have any specific questions for me.
all right. So I guess I have a question that just popped up into my mind. The question of having the trash truck stop at both properties came up last time, and at the time you were preferring a single location. I guess I'll start by asking, could you remind me, are the primary entrances to the 3 duplexes on the east side toward the new duplex, or I'm sorry, to the triplex units? Is that on the east side or is it on the west side?
So it depends on what you mean by the primary entrance. So for the townhouses, we're assuming that the homeowners are going to access the units mostly from the west side, because that's where they're going to be parking. They're going to be parking their cars and taking their groceries in, or having the kids get out of the car, whatever. It seems a little unlikely that they would park and then walk all the way around to the east side. On the other hand, the east side of the building does have existing entrances, which are nice, and I think lend a sense of community to the entire project. And in addition, if you didn't have a car, and some of our homeowners might not have a car, it might be more natural to access the property on the west side.
Okay, all right. To access the property on the west side, you said?
Yes, because you've got the porches right there. If you're coming from the center of town, let's say you're coming from Amherst Coffee, seems to me it would be more likely if you were at the Jones. Okay, you're at the Jones Library, you come home.
You mean the east side?
I'm sorry. Yes.
Okay.
My mistake. Sorry. Okay. Right.
All right. All right. Well, I guess where I was headed was, if basically the west side, where the parking lot is basically going to be used virtually all the time. Could you essentially have one trash enclosure over where you're showing the new one that's close to where the accessible unit is, and just reduce some of the paving that's running around the north end of the triplex? But that sounds like that you want to have this extent of paving, and you don't mind having two trash enclosures. So I guess I will not pursue that. Board members, any questions from you all, or has the applicant taken care of our previous comments adequately and we're prepared to go ahead with this? Anybody have any comments about that? Okay, not seeing any hands raised. You're gonna make me keep talking. Okay. All right, so I'm not seeing any comments. We still have a few attendees from the public, so I will ask members of the public, do you have any comments on this project before we vote on approval of their site plan review? And no one has raised their hands from there. In that case, Walker, you have prepared some draft findings and conditions for us for this project.
I have.
I wondered if you want to lead us through them, or do you want one of the others of us to do the reading of them?
Yeah, I can go through them.
Okay.
Do you have them, Walker?
Pam Field Sadler, do you think you can put them on? Or maybe, I don't know, I don't care whether it's Walker or Pam.
Yeah, I've got them.
Okay.
Okay.
And that way you can scroll them while you're reading, or
Yeah.
and keep them coordinated.
All right. Everybody see that?
Yes.
Yes.
Okay. So, do you want me to go through the findings and the conditions?
Well, yes, eventually.
Okay.
Let's start with the findings.
Okay. I don't have the actual site plan review bylaw in front of me, but I did when I was making the findings. So
typically we have you know, our planning staff have read these, or other members have read it if they were extensive. And we just went through each one, and if there was any wordsmithing or conversation about them, we had a chance to do that.
okay, so do you want me to just read them then?
Yeah, I think so.
All right. All right, 11.2400, the project is in conformance with all appropriate provisions of the zoning bylaw as long as the construction of a second principal use on this lot is found to be complementary to the townhouse conversion approved for the existing two-family home.
Looks good.
11.2401, town amenities and abutting properties will be protected because of the conditions of the site plan review approval.
I guess do we not think they are protected, or that there aren't impacts on town amenities and abutting properties because of the design?
There could potentially be stormwater impacts if there wasn't stormwater thing. That's a little bit more on the Conservation Commission side, but I guess I was thinking that this was more of a catch-all just in case. There could have been impacts.
It just feels a little funny for us to have a finding that depends on a condition that we haven't yet gotten to.
Okay. I haven't done findings before. I did get this from a previous one that I found from a previous project. This wording was in there, but it may have been changed in the meeting at that time. I don't know. We
Board
could also
members,
say we do not anticipate any negative impacts on town amenities and abutting properties.
yeah, I think it's something, like the design. Actually, I assume this is not a Word document.
No, it's a PDF.
Okay,
we'll
all
have to
right.
make
Well,
hand notes,
just a
but
note for in the future, we've always found it helpful to do this as a Word document
yeah, I'm realizing that now.
so that we can edit as we go.
Yeah.
So why don't you just make a note that this one I think would be better worded as something to the effect that the existing design will not impose, adverse impacts on town amenities and abutting properties.
Okay.
All right, next.
Doug, can I ask a question?
Yep.
So can we? I guess I'm trying to understand how would we guarantee that?
Well, we are depending on the applicant building this as in conformance with the design that we've approved.
Yeah, I mean, the phrasing you used before was like, "Do not anticipate," as opposed to "will be protected."
Oh, okay.
So
Yeah.
to me, I would take a softer phrasing. Walker, it's really helpful to hear that this is used. This has been used in other findings. I haven't seen this wording before in my year on the board. But I would prefer something a little softer. But I might be splitting here.
No negative impacts are anticipated could be a better way to
Yeah.
phrase it. I mean, it's not meant to be a guarantee that there aren't going to be. It's just meant to be you reviewed the plans and you didn't see anything that would cause an impact reasonably.
That makes sense.
Okay.
So the next one is a little bit similar. Abutting properties will be protected from detrimental site characteristics resulting from the proposed use because of the conditions of the site plan review approval. So it might be that we want to reword that one kind of in the same way.
Yeah.
All right. For 11.2403, I had not applicable. Eleven point 2410, unique or important natural, historic, or scenic features will be protected. And that's only relevant in this case, I think, for the historic house. 11.2411, methods of refuse disposal will be adequate. The management plan explains the use of private contractors to service the dumpsters located in front of the townhouse. And maybe we can, with the new plan, say located near each of the buildings or the dumpsters located on the property if we don't want to specify.
Right. Well, you could just end with dumpsters.
Yeah.
Mr. Chairman.
Yes.
Yeah, I have a
Sorry,
similar.
Fred.
Yeah, I have a similar issue with 11.2400. It says the project is in conformance as long as the construction of a second principal use is found to be complementary. It's our job to determine if it's complementary. Is that that's something like the board agrees that the use is complementary or something like that. We are the finders in this case, not someone else yet to be determined.
That's a good point, Fred. And that should be one of our findings.
Yeah, okay. I had
it's
it
in
as
the conditions.
Conditions, but
yeah,
we can move it up there.
Yeah. Thank you, Fred.
So, all right, moving on, 11.2412, the ability of the proposed sewage disposal and water supply systems within and adjacent to the site to serve the proposed use are adequate. Again, I guess the one that I was looking at for reference used this phrase a lot. But we might just say that they are adequate.
Mm-hmm. Yeah, I'm not, yeah, I guess
Mhm.
Hamfield Sadler.
Yes.
Do these strike you as different than some of the ones we've used in the last couple of years?
Um, they do strike me just a little bit different. I looked at the zoning bylaw, and what it says is what you're ensuring is that when you evaluated the site plan, that you used this criteria. So the planning board is finding, I think Walker, that we don't have to reference the conditions, like those will also, they will be present as part of this. And back to Fred's question about 11.2400, we also will need to vote to make that determination about the complementary use. That has been part of the application and the noticing for this project, is that the applicant is asking us to make that determination.
Mhm.
So I think
And so, Pam, you're going to want a separate vote for that as opposed to approving the findings and conditions.
that it can be all part of the same vote. I think that we just want to make sure that we remember that it's said and included. Mhm. What, Rocker, do you agree?
Yeah, I think that's correct. It's a different portion of the zoning bylaw, but it's still part of your findings and conditions.
Yes.
Okay. Fred?
Yeah, I hate to do this, but this approach seems to constantly come through this, and I'm wondering if it makes sense to postpone an action on this to our next meeting. I think it will take all of about 5 minutes to accept this if it is simply recast by staff in the ways that we've discussed, so that there are actual findings here.
All right. Thanks, Fred. Angus?
Well, I guess I have a question and then a comment. The question is for the applicant, because I know that they were kind of pressed for time. And the comment is, I was looking back at one of our earlier findings and conditions, and the findings for an earlier project simply said the board finds that the project complies with the relevant criteria of section 11.24 of the zoning bylaw. There are a couple of things here that might be worth spelling out, but most of this is just kind of pro forma, saying basically that the project complies with the 11.24. And I'm wondering if we could just say that once and not repeat all of this. So that's I guess a comment.
Yeah.
It's a question and a comment.
Okay. Well, it does look like all of the findings that have been drafted are from that section. So, so Walker, would you be okay if we, if the way we voted the findings was simply that brief, that we simply said we find that the project is in compliance with the requirements of section 11.24?
As long as you're sure that they fully are and that none of these extra comments are, that you don't need to reference the Conservation Commission order, for instance, I think that's fine.
Okay. Well, I don't want to dismiss your work without.
I mean, again, my
No.
first time doing it, I looked at one previous reference from your, I think the most recent site plan review. But if that's not the way that you want to do it, that's fine.
Okay. Further comment?
Well, I was just gonna add, I mean, the only thing that I saw that might be worth spelling out is a mention of the additional curb cut. But that's to me the only thing that isn't basically just saying everything conforms with 11.24.
Mhm. Okay, Fred?
Yeah, I'm just wondering if we can kind of change a verb in some of these so that it's we find.
Mhm.
But I don't
Well,
know.
I mean,
I can be persuaded either way.
yeah. Well, okay, so Felicity, um, how impactful would it be if we delayed our approval to August 5th? You wanted to close by the end of this month, I thought.
The closing is scheduled for July 31st. I do think that the board, should have the decision in the sort of manner that it thinks it is most appropriate. I had heard that, maybe I'm mistaken, that because there are like 3 Wednesdays in July, that it would be is it possible to just have one, are you meeting on July 29?
Well, that's a good question, and that had been in the back of my mind. When there are 5 Wednesdays in a month, we keep the 5th Wednesday available as a possible meeting. To date, we haven't discussed meeting on that date, but I guess I can ask at this point, board members, are you available, and would you be willing to meet on the 29th for this one topic as a relatively brief meeting? I'm seeing a nod from Jara. Jesse's not sure he really wants to. Oh, there's thumbs up. Okay.
I would.
I guess Fred would.
I don't think I'll be
And
able to.
you probably do. Okay. But we're likely to have a quorum. Let's see, between Fred was a yes. What about Roy? Roy, are you available on the 29th?
Yes.
Okay. So 4 of us, Fred, Roy, Jesse, Doug, and Jara, are you available?
Yeah, I'm
All right.
available.
All right, great. So that would be 5 of us. So that'd be a quorum. We could do that. All right. So in that case, why don't we plan to meet on the 29th? Felicity, we'll hope we can finalize our approval on the 29th. And Walker, why don't you lead us through the rest of these so that we can talk about, if there's things in here that we really want to make sure we mention specifically, or whether they can just be part of the catch-all phrase that was talked about, that the project's in conformance with 11.24. Are there other
Okay.
things that you feel like maybe we may want to mention specifically?
So we've got the stormwater water management systems are appropriate because they were approved by the Conservation Commission.
Yeah.
Landscaping is adequate, as shown on the plan. Adequate soil erosion controls. No nuisances are anticipated. The lighting will be, this one's also referenced as a condition, but the lighting won't be an issue.
Yeah.
project has been reviewed by the Conservation Commission and the wetland will be adequately protected because of the order of conditions. Meets the setbacks, parking, location, etc.
Okay.
Avoids impacts to wetlands, relates to the existing building, adequate screening is provided for dumpsters. Means the safety of vehicular and pedestrian movement is been provided. We did have this one additional curb cut has been determined to be necessary to the function of the site. And so maybe it doesn't totally meet the requirement that the location and design minimize turning movements and hazardous exits and entrances, except that because it's necessary, I would say that that probably is the minimal required. The parking spaces, drive aisles, and sidewalks are appropriately located. We're waiving the requirement for traffic impact statement.
Yeah, again, Mr. Chairman, could you go back to that one?
The traffic impact?
Yeah. That's got to have an affirmative. The board waives the requirement for a traffic impacts study because it is unnecessary or something like that. Again, it has to be an affirmative statement.
Right, more a definite rather than it will be waived in some ambiguous way. Thank you, Fred.
You might just try is waived. Just a suggestion.
All right, so that's, if there's no other comments on the findings, I think you're correct that probably a statement that the project meets the requirements of section 11.24 would be sufficient in this case. And then a statement that the traffic impact statement, that the board has waived the requirement for traffic impact statement because it is not necessary.
All right, why don't we go to the conditions?
So again, I mostly took these from previous projects. It seemed like there were a lot of conditions that have been used frequently. So the site plan prepared by Bucky Sparkle, dated these dates. I think I need to
I thought we had drawings that were dated the 13th of
Yes, I have not updated this since we got the new drawings,
okay.
so I'll add those.
All right.
And that represents the new site plan for the property. I'm gonna run away for just 1 second. My dog needs to go out. I'll be right back.
Okay.
Project shall be built substantially in accordance with plans submitted to the planning board and approved on, I tentatively have July 15th, but we'll presumably have July 29th.
Yep.
And again, I will add the additional updated plans we received. Management plan has not been updated, and the duplex plans and elevations have not been changed, so those are still accurate. Substantial changes to the project and/or substantial changes to any approved site plans shall be submitted to the planning board for its review and approval for the work taking place. I think, the purpose of the submittal shall be for the planning board to approve the change or determine if the changes are de minimis or significant enough to require modification of the site plan review approval. That's pretty standard. The approval shall expire within 2 years of the date that it is filed with the town clerk, unless it has been recorded with the registry of deeds and substantial construction or use has commenced within that period. And all work associated with the project shall be completed within 24 months from the date of issuance of the building permit, or they can request an extension. Those are the standard ones. The affordable housing conditions are a little more specific, and a lot of these are the same or similar wording to the special conditions the conditions in the special permit from the ZBA, and I was trying to be consistent between the two.
Okay.
The proposed second principal use of an affordable owner-occupied duplex shall be considered complementary to the existing residential principal use. So either we
Yep.
leave that here or we make that a finding, I'm not sure. The duplex shall include 2 dwelling units. The unit sizes shall be 1 ADA accessible 2-bedroom, 1 bath, and 1 3-bedroom, 1.5 bath. The duplex units shall be permanently affordable in compliance with the definition of affordable in Article 12, Section 12.24 of the Amherst zoning bylaw, which is then given. This is just the definition. A certificate of occupancy shall be granted upon approval of the following documents. EOA shall see approval of the local initiative program, local action unit application, and affirmative fair housing marketing and resident selection plan by the appropriate state agencies. The affordable units shall be available and the homeowner selection process shall be complete at the time of any full or partial certificate of occupancy for finished units. However, at the discretion of the building commissioner, a certificate of occupancy may be issued and exclude the affordable units until the owner selection process has been completed and inspection service has been provided documentation of the completed selection process. The affordable units shall be owned at all times only by qualifying homeowners in accordance with the regulatory agreement. When the units are sold, they will be eligible for inclusion on state subsidized housing inventory or SHI. The SHI application, it should say, will be submitted by town staff. A violation of the affordability requirements for any units shall require modification of this special permit. The site plan review permit, I guess, and be accompanied by a written recommendation on any changes from the Amherst Municipal Affordable Housing Trust or its successor. The affordable units are to remain affordable in perpetuity, term of 99 years. Subject to UAHLC approval, this requirement shall be included in the permanent regulatory agreement. Affordable units shall be marketed and sold to income-eligible households in accordance with UHLC regulations and guidelines for the local initiative program, which require the approval by a UHLC of an affirmative fair housing marketing plan. The costs associated with the development and implementation of the marketing plan, including advertising and processing for the affordable units, shall be borne by Amherst Community Land Trust. And, subject to the approval of ACLT and EOHLC, a qualified agent shall be engaged by the applicant to administer the initial marketing and lottery for the affordable units in compliance with the income eligibility requirements for the homeowner of the affordable units.
Mr.
And
Chairman,
I should say that, right quick, that these,
Fred, if I missed you again, I'm sorry.
yeah, it's on item 12, it says this special permit, is this not a site plan review?
Yes.
yes, it will need to be updated.
That is not a special permit.
Correct. Okay, I'm sorry I had my view of people's hands obscured, so Felicity.
And I just wanted to add that these particular conditions were provided to the applicant ahead of time and were reviewed by Felicity and Linda, and that they provided comments and approved them, the wording that we have here.
All right, so I see and Angus and maybe Fred, or maybe that's a legacy hand from Fred. So Felicity, go ahead.
So I got a couple of things. I got these actually from Bruce right before, like this afternoon. So I haven't really done a deep dive on them.
These are the same ones that the ZBA proposed. Like we went through them when you were doing the ZBA.
Oh, okay. I misunderstood.
Review them. Yeah.
I misunderstood. Okay. The other thing I was going to mention is, does the site plan review decision, is that recorded? Because I thought that was not recorded, but if I'm happy to do it. I thought that I recorded the special permit, but not the site plan review.
I believe you're correct. Does it mention recording in here somewhere?
Yes, it did.
Condition number 4.
Yeah.
Yeah.
Oh, up above. Oh, yeah. Okay, so we can take out the unless it has been recorded at the registry of deeds and just say unless substantial construction or use has commenced.
Angus, I'm going to call on Linda next and then you.
Sure.
Linda? Linda, I see your hand up. You are muted at the moment. There you go.
Thank you. When this was, the conditions that were written for the special permit were explicitly for the townhouse conversion. It also added the complementarity of the two buildings, but they did not review intend the timeline to mean that the whole project, including the Habitat duplex, would be finished. The actual plan is that we will begin construction this summer, and we hope to have families in place in the fall of 2027 in time to start the school year. Habitat will be just starting their construction, and although the timeline calls for that to be complete within a year, this is to actually say the whole thing. When you're looking now at the site plan, then you're basically acting on the whole project, including two separate constructions. 2 years is doable, but it's tight if they can't begin promptly, which sometimes happens because they have multiple projects going and have to do things when it's possible in various cases. I'm a little concerned that we're setting ourselves up to need to ask for more time than 2 years.
Mm-hmm. Well, would you be comfortable with 3?
I would think so. Bruce can comment on that. He's very experienced in working with Habitat.
All right, Bruce?
Yes, Doug, I think 3, because 3 also is the amount of time that we have to complete the work in the order of conditions from the Conservation Commission. So it would put those two together. And if we have to apply for more, if it does take longer, then it's not just the planning board that would be come back to, it would be the Concom. So I think 3 is a good number. And it's true that Habitat has had some delays on projects, and we've got 10 projects in the offing. Because 2 of about 6 or 8 of these houses have been waiting for legal resolutions on complex site issues for the past 2 years. So it's created a logjam for Habitat. So 3 years is a very good thing to do. I would hope that you would agree to do that.
Angus, I'm going to call on you, and then we'll come back and I'll just ask for a consensus about whether 3 years is acceptable to the board. Go ahead, Angus.
Sure, 3 years sounds great to me. My question is about condition number 6, and that's just asking Linda and Felicity if that phrasing "shall be considered complementary" is fine for what they need from us.
I think so, but I'll defer to Felicity what the legal custom is in the use of that verb.
I would suggest, first of all, is this the finding about complementarity? Because if this is the finding about complementarity, then we should not use the phrase "shall be considered."
Yeah.
We should say the planning board finds that the second principal use of an affordable owner-occupied duplex is complementary to the proposed, I would say to the existing residential principal use, as modified by this special permit, the approved special permit,
as approved by the special permit.
Yes.
Yeah, and I think it actually belongs under findings.
All right, I'll move it to findings and reword it.
Okay, yeah. All right. Let's see. I don't see any hands, but board members, is there any objection to us for, I think it was conditions 4 and 5, using a time, or just number? Well, it probably is both 4 and 5, because to use the 3-year period. So it's be 2 years, 3 years under condition 4 and 36 months under condition 5. Bruce?
Not to shoot myself in the foot because I'll probably be the construction manager for this, but the 24-month period in number 5 starts with the issuance of the building permit, which is unlikely to happen before 2 years from now. So I think 24 months there is fine and probably appropriate and certainly appropriate. So I would only suggest
well,
you.
Bruce, aren't there going to be 2 building permits?
Yes, there will be.
And the way that, so this site won't be completed until the second building permit project is finished?
That's correct, and that's why the conversation that was had with Rob Mara that allows the certificate of occupancy to be issued on the townhouse can be issued prior to the completion of the full project. But basically, in the case of the townhouse, it was the site work. So we've established that we can get a CEO for the townhouse prior to the completion of the entire site work and this duplex. So the duplex is fine, but we're good for the townhouse because that's been separately dealt with.
Okay, so in that case, I'm going to suggest that for condition 4, we use 3-year time period. And that condition 5, we leave the 24 months, but we add after the words building permit on the second line, the building permit for the duplex, something that describes that we're talking about the duplex building permit rather than the townhouses. All right. And I guess I'll just ask again if anybody has any objection to that. Not seeing any hands, so I hope that'll get incorporated into the next round. Okay, so Walker, let's go back to where you were.
There's no more. Were there any other comments on the affordability conditions?
Yeah, I think the main one was to change the word special permit in number 12.
Okay, so building exterior and site improvements. We don't need this one because that was going to be a condition if you didn't get the updated plan.
Right.
So we can skip that one. Landscaping shall be installed in accordance with the site plan, and once installed shall be continually maintained. And all disturbed areas shall be loamed and seeded unless otherwise specified. There shall be no more than 10 cars parked on the property as shown on the 2026 site plan. I think that should have the 7/13 date on it. All parking spaces shall be delineated. New accessible parking space.
Could I interrupt?
Yes.
That was the only thing I wanted to ask whether you might consider deleting the section about all parking spaces shall be delineated. That sentence, the last sentence, all parking spaces. This is a stone permeable paving, and it really can't be delineated. That's why we're actually using. You may not have noticed it, but we're actually using the bollards with the charging conduits and charging heads on them as the essentially the delineation, if you like. But I would prefer, if possible, for that sentence to be eliminated because it might be construed that it should be striped, and that would be basically impossible on a gravel driveway.
So it's a gravel surface?
Yes, it's a permeable surface. It's a very specifically very specific driveway treatment that satisfies the Conservation Commission.
Because I'm familiar with a permeable sort of asphalt, and that's, I guess, what I thought it was.
No.
And, okay.
Now, it's pretty
All
clearly
right,
shown on the drawings that the revised version of which was submitted yesterday, I guess.
Yeah, obviously I missed that.
I mean, they're delineated by implication, because, as I said, by the location of the bollards. That will kind of regulate the way in which the parking is done.
Yeah, okay. Angus?
Yeah, I think it should be eliminated.
Okay. All right. Unless anybody objects, we'll take that out.
All right, the new accessible parking space of the duplex shall meet ADA standards and shall be provided. Shall we just say signage here rather than or striping?
Yeah, it doesn't look like we're going to be able to do any striping.
Yeah. All exterior mechanical equipment associated with the duplex shall be screened. All exterior lighting shall be downcast and shielded in order to be dark sky compliant. And the new parking lot shall be screened from view from Amity Street and the adjacent property with evergreen plantings that are a minimum of 3 feet at time of planting in accordance to section 7.112 of the zoning bylaw.
All right.
Any other building exterior comments?
And most of the rest of this is probably sort of standard.
Yep, the work in the right of way will be approved by the DPW. Any town amenities or town crosswalks, sidewalks, etc., shall be reconstructed to match existing. The project shall comply with and be managed in accordance with all terms of the management plan. Trash and recycling shall be kept in containers. I said in the enclosure by the stepping stone path as indicated in the management plan. I will take that specific phrase out.
Yeah.
And containers shall be returned to the storage area by the waste hauler immediately after collection. As indicated in the management plan, the 2 surface stormwater detention basins will be cleaned out to remove any accumulated sediment or debris. I don't know if that needs to be a separate condition since we already say that they're managed in accordance with the management plan.
I think there is I do have some question about some of these, about whether they really need to be repeated again.
Yeah.
Some of the ones just up above, it's like, I mean, like the dark sky compliance. I mean, we've approved the plans and the lighting, and it ought to be dark sky compliant in the plans, and we've said it has to be built the way the plans are. So do we need to say that again? But I don't remember what we usually do. Okay. All right. And then the construction
ones are all standard.
All standard.
Yeah. I don't think I put anything different or new in any of those.
Okay. All right. So
and there's completion of work is also all standard.
Right.
Yep, that's it.
All right. Thank you. Okay, so I guess I'm gonna move that we continue this hearing to July 29th. Pam, is any reason not to do 6:35? Or should we?
Not that I am aware of.
Should I do like 6:32 because we're not going to do anything else?
Would you like to say 6:30?
Yeah, let's say 6:30.
We can say 6:30.
All right, so I make a motion that we continue this hearing to July 29th at 6:30 p.m.
Second.
Thank you, Angus. All right. Anything else, Felicity, from your team before we continue?
Not at all. Just our hearty thanks for all the time you've put into this. We really appreciate it.
Okay, thank you. I don't, are there any public comments on this project? I think I asked that earlier, so don't see really anyone raising their hand. Okay, we'll go ahead and vote to continue. Starting in the reverse order, Jera,
Aye.
and Jesse,
Aye.
Angus,
Hi.
Roy,
Aye.
Fred,
Aye.
and Bruce. Not Bruce. Bruce is
Right. No, Bruce.
not part of this vote.
Yeah.
All right. So 6 in favor, 1 member recused. The motion carries. This hearing is continued.
Thanks very much.
Okay, thank you, Felicity and Linda. We'll see you in another 2 weeks.
Thank you.
Okay, the time is 9:11. Fourth item on our agenda. Is Bruce back in the room? Yes. Okay, fourth item on our agenda is Planning Board elections and reorganization. We started talking about that last meeting. We have the 3 officers, and then we have the 3 boards that we have liaison representation on. So I guess I want to just start by saying, Bruce, you asked me last time if I was willing or interested to be chair again, and I think I wasn't really as positive as I've ended up feeling like I should have been. So I'd be happy to be chair again if that's what the board would like, and I'll just stop there. So with that, I guess I guess we ought to go through each office one by one. Does anybody want to make any nominations or volunteer for positions? Jesse?
I would nominate Doug Marshall to be chair.
All right. Are there any other members who want to make a nomination or volunteer to be chair? Bruce, your hand is the second one up.
Yes, I was seconding the nomination. I wasn't sure whether that was the process. I assumed it was, but maybe that's happens later. So I'll
Well, I
just
think
do
we ought to
what.
go through them one by one and start
Yeah.
with the chair so that we know who's left to do other things.
Well, since I've got my hand up, I'll do what you did and say that I will happily continue in the role of clerk, but I will also accept any other role that the board is interested in
Okay.
assigning.
All right. Let's see. Would anybody like to volunteer to be vice chair? As I said last time, there are basically no responsibilities unless the chair does not show up or is unable to preside at a meeting.
I have interest. Oh, Jesse, sorry.
Who said that? Oh, Jera.
I did, yeah, but
Okay,
also
Jera.
Jesse.
Well, I was going to nominate someone else. So I nominate Jack to be vice chair.
Well, never mind.
I'm sorry,
Thank
Jesse.
you.
Who did you nominate?
Jara.
Oh, okay. All right. Well, I think we are going to probably need to vote on these one by one.
Yes.
Although I'd be perfectly happy to do it as a full slate all at once.
Mhm.
Pam, do you agree we need to do them individually?
I mean, I think that the preference is to do them individually because if you do it all together, then there's no opportunity for somebody to refrain from
object
voting.
to one or the other.
Right. Yep.
All right. All right. Well, it's only 9:15, so.
Only.
All right. So let's go ahead and do the 3 votes for the
Okay.
for the 3 officers. Chair, vice chair, and clerk. Was there anybody else that wanted to be clerk? I mean, should we have any do we Are we going to have any contested votes? Okay. All right, so I'll go through, we'll start with the chair. Members, I will ask you to vote in the affirmative for, or in the negative for Doug Marshall for chair for the next year. We'll start with you, Bruce.
Doug, before we do that,
Oh, I'm sorry.
I need like, because these are motions and individual motions,
Okay.
we need a 1 and a 2, and
Okay.
so,
All right, so Bruce made a motion to nominate Doug Marshall as chair.
okay.
Actually,
Jesse
did.
seconded.
Okay.
And I seconded the motion, or at least I was ready to.
Okay.
Two.
So I think we have the chair. We have the 2 names associated with the chair.
Yes.
Okay, so let's go ahead and vote on the chair. Bruce,
Aye.
Fred,
Aye.
Roy,
Aye.
Angus,
Aye.
Jesse,
Aye.
and Jara.
Aye.
All right.
And Doug?
And I'm going to abstain just because I don't feel like voting for myself tonight. So that's 6 in favor, 1 abstention. That passes. Doug's the chair for the next term. Vice chair, we had a motion for Jara, both from Jara and from Jesse.
I'll second that. Make it easy.
Okay, so Jara nominated himself and Jesse seconded.
Okay.
All right, we'll go through again, starting with you, Bruce.
Aye.
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 Angus.
Aye.
Jesse.
Aye.
I'm an aye, and Jara.
I'll follow your lead and abstain.
Okay. All right, and then for clerk, Bruce, you volunteered.
I second.
Angus will second. Okay, great. All right, starting with, I'm going to start with Jara this time.
Aye.
And I'm an aye. Jesse?
Aye.
Angus?
Aye.
Roy?
Aye.
Fred?
Aye.
And Bruce?
Well, I'm going to flow with the dignified deference that seems to have
All right.
abstained.
All right. So we have our 3 officers for the coming year.
Nice.
Moving on to our committee and liaison reports. So we have the 3 committees, the Pioneer Valley Planning Commission, Community Preservation Act Committee, and the Design Review Board. And so let's start with PVPC. Who is interested in doing that? Is anybody interested in?
I'll continue. I'll offer to continue.
Okay, so we have Bruce who's thrown his hat into the ring. Anybody else? All right. For CPAC, Angus, you've been doing it, but I think we're hoping we can find somebody. I'm hoping we can find somebody else.
Me too.
Since you're going to be pretty occupied. Roy, I see your hand.
Yes, I would be interested.
You would. Excellent. Excellent.
I second.
I guess seconds. Okay.
And Roy, just to let you know, they're going to hold meetings a little earlier to kind of onboard the committee members because there were a lot of applications last year, and I hope this year there won't be. as many. But they're normally they don't start meeting until October or November, and I think they're going to try to meet earlier. So it'd be good to if we vote you in, it'd be good to get you sworn in sooner rather than later.
Okay. Roy, your hand is still up. Do you want to say something else?
No, I forgot to take my hand down. Sorry.
Not a problem.
No
Okay, so
no campaign speech here.
all right, so we have one nomination for CPAC, and then Design Review Board. I had volunteered to fill the empty seat earlier this calendar year and haven't seen any action from the town manager. So I'm willing to keep my hat in the ring, but I don't know if it'll ever happen. Does anybody else want to do that? I'm not highly committed to it. All right, I don't see any other hands, so that would be Doug
Second.
for DRB. All right. Pam, do you feel like you've got a motion, a nominee and a second for each of these three?
I do.
Okay, good. All right, so we'll run through Pioneer Valley Planning Commission vote for Bruce, starting with Fred
Aye.
and Roy
Aye.
and Angus
Aye.
and Jesse.
Aye.
I mean, aye, and Jara
Aye.
and Bruce.
I'll abstain. Let's keep it wholesome here.
Okay. For Community Preservation Act Committee, we have Roy Johnson as the nominee. Starting with you, Bruce.
Aye.
And Fred?
Aye.
Roy?
I'll abstain.
All right, thank you. Angus?
Aye.
Jesse?
Aye.
Jara?
Aye.
And I'm an aye as well. And then for DRB, we have Doug Marshall, starting with Jara.
Aye.
Thank you. I'll abstain. Jesse?
Aye.
Angus?
Aye.
Roy?
Aye.
Fred?
Aye.
And Bruce?
Aye.
All right. All of those were 6 in favor and 1 abstention. Thank you all.
Well done.
Our agenda. Number 5, time is 9:24, by the way. Number 5 was old business topics not reasonably anticipated. The one topic that I thought I might mention is for those of you that are interested in the ADU discussion and the hearing for the one ADU that's been protested at ZBA is next week on the 23rd. Walker or Pam, do you know what time ZBA meetings usually start? I think it's 6 o'clock from when my wife.
I think it is too. But we could confirm that and let everybody know. It's posted on the website too.
Okay.
Yeah, I think it's 6 o'clock. I actually did all of that stuff, and I'm sorry, I'm just drawing a blank, but I can be sure to let everybody know.
Okay. Any other old business? Walker, you're muted.
Sorry. I have the calendar open right here. It is 6 o'clock.
Okay.
Yay!
And is that the first item on the agenda?
Yes.
Yes. Okay.
Aside from
All right.
minutes,
Mhm.
That's not anticipated.
Okay, so I'm not going to email everybody. 6 o'clock.
Okay, thank you.
You're welcome.
Any other old business? Pam or Walker? Okay, any new business not anticipated? No? Form A&R subdivision applications?
No,
All right, ZBA applications. Other
I
than
don't
the,
have any to share. It was just the ADU discussion. Walker,
Okay.
do you?
no? Okay. SPP, SPR, SUB applications. Anything coming down the pike? I mean, you've mentioned a couple of projects that are out there. I think there's one on Southeast Street that is lurking.
Yeah, we don't have any actual submitted applications, and none with an expected submittal date.
Okay, all right. All right, Planning Board Committee and Liaison Reports. Bruce, anything for PVPC?
No,
All right. Angus, anything for CPAC?
No, I already said my piece. Roy, it's a fun committee because you're dispensing money. So I hope you enjoy it. It was a lot of work though, and I hope there's not a Jones Library project again.
All right, and I don't have anything for Design Review Board. I have nothing for report of chair. Walker, anything for report of staff?
Yeah, just a couple of things. Pam added to the packet, what was it, this morning at the last minute, the update about Hampshire College, the project going on at Hampshire College. There is going to be a virtual information session on July 21st from 6 to 8 p.m. If any of you are interested in attending, there is now a website available, a web page specifically for the Hampshire College project that you can register for. So that is in that update that Pam sent out, and you can also find it on the town website. It's currently like one of the bulleted news items. And then that process is going to continue on with more opportunities for public engagement through, they're predicting January 2027 is when they want to have their final deliverables done.
Okay.
The design standards are closed for comments, but if any of you have any that you forgot to submit, this would be your chance. Otherwise, we're going to start compiling the comments and get a final draft of those ready to go. And then the East Amherst zoning updates, the RFP, the proposals came in. We had a meeting on Tuesday with the committee, and a consultant was chosen. So we're going to be notifying them and awarding them the contract next week. And then we anticipate that they will be coming to the planning board probably in September once they have their first round of existing conditions and sort of preliminary information gathered so that you can start to get an idea of what the project is about and what direction they're thinking of going and, you know, be involved in the process. If anyone's interested in being involved earlier than that, let me know. There are opportunities. And yeah, I think that's all I had.
All right. I've realized I also meant to bring up Jesse's interest in advancing some of the topics that the housing subcommittee was working on before essentially we suspended that group. Jesse, you know, we had a couple of emails back and forth. Would it make sense for, you know, I mean, we could put it up to just have you guys, one of you show up and say, these are the things we've been working on, and have a discussion at least with, you know, that people like me can at least listen to as subcommittee members discuss where they want to go next.
Yeah, I mean that's fine. You know, what I was raising was sort of the pre-discussion of just the discussion, which is what would often happen at the subcommittee about things we think are worth pursuing. And we can do that as a full board. But then again, I don't know when I was wanting to find how we can start to shape things up.
Mhm.
because there's not going to be a lot of planning board time to do it.
Mhm.
And so, yeah, of course, if we block time, that's great.
Well, I mean, let's at least try it on the 29th. We don't
Sure.
have anything else on the agenda. I mean, Angus won't probably be with us, but life
Yeah,
will,
sure.
you know, let's try that. So Pam, could we put on as a second agenda item? You know, I don't know if we need to call it housing subcommittee topics or potential housing
I mean, it could just be
zoning initiatives or something.
on the subcommittee. We always just sort of listed general housing discussion, and then it was open
Okay.
and not.
And that's what we've had on the planning board agenda. And I actually gained that idea from Nay, who of course was the liaison to the subcommittee. So we've had a general header of general housing discussion, and then under it we just kind of bulleted what we knew was going to be there. So if somebody is going to come like from the subcommittee and kind of give us a report, whether that be Jesse or whatever.
Well, I think for this one, let's just say general housing discussion and leave it at that for the moment.
Okay.
Because, I mean, I think Jesse and Bruce and Fred will initiate the conversation, and then we'll see where it goes.
Yep. And then I also, for August 19th on my schedule, for some reason I put down PRP, because Angus, were you doing some work on PRP and thinking you might have something ready for August 19th?
I think what we're waiting on is me and Roy to do the next steps on that.
You and
Yeah.
Roy. Okay.
And Roy
Okay.
has his hand
Walker
up. I think he was going to do some research or something.
and Roy. Okay.
Roy, did you want to say something?
Yeah, so I started working on the project, and I was able to get a hold of all the owners except for one parcel, and I got a real positive response from everybody. They're really interested in working with us and trying to figure out how their properties would best help the town. Some of them were housing, 55 and over, mixed use, and things like that. So I think maybe for the next meeting, I could have a kind of a more full report. I'm going to meet with a couple of them, but the response was really, really exciting that they're really interested in working with us. So that was great.
All right. That probably should have been an old business conversation, but I forgot about it.
Next time.
Yeah.
Well, August 19, right? I mean, that's when we're scheduled to talk about it again.
Right.
So it will be under the general housing discussion for that night. Okay.
All right.
All right.
All right. Is there anything else I missed that we want to talk about before we adjourn? Roy, is your hand still up, or is it you want to say something else? Okay. All right. Time is 9:34 and we are adjourned. We'll see you July 29th, that fifth Wednesday. Good night.
Thanks.
Night. All right. End the meeting. Oh, wait. Stop the record. Stop the recording.